So let's pick up on that because Prince Harry has indeed arrived at the High Court in London.
At exactly 10:14 in the morning, something broke, and it wasn't the silence. Courtroom 3 at the Royal Courts of Justice had been running on routine, papers shuffled. Barristers traded folders. Reporters wrote in shorthand without looking up. It was day 17, long enough for tension to settle into procedure. Nothing dramatic. Nothing explosive. Just law moving at its usual careful pace. Prince Harry sat in the witness box, shoulders squared, expression controlled, since the session began shortly before 9:45 a.m. He had answered questions with restraint. The case itself, centered on alleged privacy violations and media misconduct, appeared to be following a predictable path. Then the judge read a single line. There was no raised voice, no dramatic pause meant for theater. Just one sentence drawn from a private message submitted as evidence by the defense, and make him tear up when discussing Diana. The words were delivered in the same neutral tone used for every other exhibit that morning. But the air shifted instantly. People in the gallery would later describe the sensation as physical, as though the oxygen had thinned. Even those who hadn't fully grasped the implication felt something tighten. Harry did. Witnesses seated behind him noticed his jaw lock. His fingers, resting on his knees, curled inward. The rigid posture he had maintained all morning softened, not gradually, but suddenly, like a brace snapping under strain. At 10:15 a.m., he lowered his head. Both hands came up to cover his face. It wasn't theatrical. There was no outburst. No shouted objection. Just a small, involuntary sound. Half breath, half sob, barely audible, but unmistakably human. The kind of sound you can't rehearse. For a moment, the entire courtroom froze. Pens hovered above notebooks. One senior usher instinctively stepped forward before stopping, unsure whether protocol allowed intervention. Even the court sketch artist paused midline. Up to that second, this had been a legal dispute. A prince challenging the press. A familiar chapter in Britain's long history of royal media tension. But in that instant, the focus changed. It was no longer about newspapers. It was about trust. The messages in question were part of a private exchange between Meghan Markle and a longtime acquaintance in California, someone described in court as a trusted confidant from her pre-royal years. The correspondence dated from late 2022 into early 2024. They were never meant to be public. Not meant for headlines, and certainly not meant for Harry to see in open court. Yet there they were, read into the record, preserved in transcript, impossible to retract. Justice Thornberry had warned moments earlier that the material would be unsettling in implication rather than explicit language. As she continued, the implication sharpened. The reference to Diana, Harry's mother whose death has shaped so much of his public identity, suggested something calculated, not remembered grief. Positioned grief, not spontaneous vulnerability. Scheduled vulnerability. Harry did not look up again. At 10:18 a.m., his counsel rose briefly, requesting a recess on the grounds of emotional distress. The request was denied. Procedure, the judge reminded the court, must continue. And so it did. But something irreversible had already happened, because what unfolded wasn't merely embarrassment. It wasn't even betrayal in the simple sense. It was recognition, the kind that lands heavy and refuses to move. For years, Harry had framed himself as someone fighting manipulation, particularly by the press. Yet here, in the most formal setting imaginable, he was confronted with the possibility that narrative shaping might not have come only from outside forces. Observers would later call it a symmetry too sharp to ignore. A man who had accused institutions of failing him now sat in an institution, a courtroom, confronted with the possibility that trust, once freely given, had been curated around him. The rest of the morning proceeded in technical language. Dates were confirmed. And context clarified. No dramatic confrontations followed. No shouting matches. But the temperature of the trial had changed. The story was no longer about what the press had done to Harry. It was about what Harry might be realizing. And beyond that courtroom, something else was already in motion. Because while one truth was cracking in public, another process had been unfolding quietly behind palace walls. one that had nothing to do with emotion and everything to do with structure. Silence, in royal terms, is never empty. It is preparation, and the preparation had already begun. Here's the part most people misunderstand about the monarchy. When it goes quiet, that's when it's working. In the weeks following rising internal concerns around Meghan Markle's narrative and documentation, Buckingham Palace did not rush to deny anything. There were no fiery briefings. No counter-accusations whispered to tabloids. Instead, the palace withdrew. Engagement calendars shifted subtly. Access to senior aides narrowed. Longtime royal correspondents, people who know how to read institutional body language, noticed the cooling almost immediately. It wasn't dramatic. It was deliberate. Constitutional analysts later described the shift not as damage control, but containment. Rather than addressing individual claims, advisors reportedly began reassessing the framework itself, the system that had allowed certain representations to pass without deeper verification. Because at the heart of the concern wasn't publicity, it was credibility. For centuries, the monarchy's authority hasn't rested on force. It rests on continuity and public trust. The idea that lineage, succession, and identity are beyond ambiguity. If narrative outruns documentation in those areas, the risk isn't embarrassment. It's structural. Behind closed doors, briefings reportedly included constitutional lawyers, medical ethics consultants, and governance specialists. The guiding principle was simple: verify, not accuse, not retaliate. Verify. What documentation exists? What was independently confirmed? Which safeguards were treated as formalities rather than checkpoints? According to sources familiar with the review, what unsettled advisors wasn't one glaring inconsistency. It was a pattern of small gaps, dates aligning too conveniently, confirmations relying on representation rather than corroboration. Individually, none of it constituted wrongdoing. Together, it raised a quiet but dangerous question. Had trust replaced verification? That question matters deeply in a hereditary system. Royal procedures surrounding succession are intentionally precise. Medical confirmations, witness attestations, registrations. These aren't ceremonial. They exist to eliminate doubt before it forms. Yet modern royal life has adapted under media pressure. Privacy, compassion, and speed sometimes reshaped processes once built for slower eras. Those adaptations created blind spots. Internally, the language used was cautious, a procedural insufficiency, verification deficit, inconsistency, no accusations, but no dismissal either. Importantly, the review did not issue findings. It cataloged uncertainties. It flagged anomalies. It deferred judgment. That restraint was strategic. Any premature action could appear punitive. Any emotional reaction could be framed as hostility. So the palace did something radical in a media age. It stepped outside the spectacle. And in doing so, it changed the battlefield. Momentum has always been central to Meghan's public strategy. Interviews leading to documentaries, documentaries leading to contracts. Public resistance often amplified the narrative, but without engagement, there is no amplification. Without rebuttal, there is no friction. Silence removed oxygen. Observers began noticing something subtle but profound. The monarchy was no longer debating claims in public. It was examining process in private. And once a monarchy shifts from sentiment to structure, the conversation hardens. Because institutions don't argue feelings. They adjust frameworks. By early spring, the internal review had entered its most sensitive phase. Documentation over testimony. Paper over perception. And that's when the issue intersected with Harry's courtroom moment in an almost painful symmetry. In court, he encountered the idea that personal vulnerability might have been positioned. In the palace, advisors confronted the idea that institutional trust might have been relaxed. Both realizations revolved around the same theme. Belief without verification carries cost. No conclusions were announced, no reforms declared. But internally, thresholds were being discussed. Specifically, at what point does ambiguity become unmanageable? In constitutional terms, that threshold is reached when questions touch succession. However, indirectly. And once succession is involved, tolerance narrows quickly. Because in a monarchy, there are few absolutes. Succession is one of them. There is one rule monarchies never break. This was no longer about public relations or reputation. It was about governance. Experts consulted during the review emphasized a principle that sounds simple but carries enormous weight. Children must never become instruments of narrative, not for leverage, not for symbolism, not for negotiation. Protection is foundational. Sources describe what followed not as punishment but recalibration. Titles weren't immediately withdrawn. Status wasn't publicly challenged. Instead, access pathways narrowed. Commercial uses of royal identity faced stricter scrutiny. Future representations involving children were flagged for enhanced review. It was structural tightening, quiet, clinical, nearly invisible to the public eye. At the center of this phase stood the Prince of Wales. Those familiar with Prince William's approach describe it as custodial rather than corrective. He didn't brief against his brother. He didn't express public frustration. He emphasized process. That distinction matters. As heir apparent, William's authority comes from stewardship. His responsibility isn't to resolve emotional conflict. It's to ensure unresolved issues don't evolve into constitutional risk. In that sense, the issue stopped being personal. It became systemic. Legal scholars often point out that succession frameworks are designed to function independently of individual intent. They assume good faith, but they don't rely on it. When gaps appear, the response is procedural, not moral. For Harry, this shift may have been the most disorienting of all. He has often interpreted institutional behavior through personal experience, betrayal, hostility, indifference. But institutions don't experience emotion. They operate on continuity. Publicly, the recalibration was almost imperceptible. Privately, it was decisive. By early 2026, advisors were no longer debating reconciliation. They were discussing coexistence under defined limits. The question wasn't a how do we restore trust? It was a how do we function without requiring it. That is a profound change. And then timing entered the equation. The Sovereign Grant Review scheduled for March 31, 2026, transformed symbolic questions into financial ones. Funding structures, security provisions, administrative recognition. All of it intersects with legal clarity. Biology, law, and finance converged into a single pressure point. At that stage, 3 strategic paths reportedly emerged. 1, direct legal confrontation, a transatlantic battle over documentation standards. American records versus Crown protocols, years of jurisdictional complexity, high drama, high risk. 2, administrative omission, proceed quietly. Leave questions unresolved, but allow names to fade from official frameworks over time. No accusations, no announcements, just absence. 3, structural reform through new letters patent, modernizing criteria for titles and succession eligibility universally. Apply rules broadly. Eliminate ambiguity without naming individuals. Of the 3, the third path was considered the most durable. Change the structure, not the people. In doing so, personal grievance becomes irrelevant. No accusations are required. The framework simply evolves. And those who cannot meet the new standards are excluded by default. In constitutional terms, it's devastatingly effective, because the monarchy doesn't defeat opponents. It outlasts them. As these frameworks were drafted in neutral legal language, designed to survive judicial scrutiny and parliamentary debate, one philosophical shift became clear. Trust was no longer sufficient. Verification was becoming the new baseline. For Harry, this placed him at an impossible intersection. To cooperate would require accepting procedural standards he had long criticized. To resist would risk watching his children's royal identities diminish not in scandal, but in silence. And systems are cruel in one specific way. They don't argue. They continue. By the time the High Court adjourned that day, the day of the single line that changed the room, palace insiders already understood something. This would not be resolved by emotion. It would be resolved by structure. History remembers scandals. It rarely remembers recalibrations. But this moment may ultimately be remembered not as a dramatic fall, not as the exposure of one person or the humiliation of another, but as the point where a centuries-old institution quietly chose continuity over sentiment. Behind palace walls, Patience reportedly expired in early 2026. Contingency frameworks were finalized. Neutral language. No references to scandal. No names. Just future-proofing. The objective was simple. Never again allow recognition to precede verification. For centuries, royal legitimacy operated on trust. Declarations accepted, lineage assumed, tradition upheld. That era is closing. In a world of global media, digital records, and legal activism, the monarchy appears to be shifting from faith to documentation, from narrative to evidence. For Meghan, the institution does not frame her as an adversary. Institutions don't wage personal battles. They absorb and adapt. Motives don't matter. Compliance does. If compliance doesn't arrive voluntarily, the structure proceeds without it. For Harry, the cost is more intimate. Over the past decade, he defined himself through rupture, leaving, exposing, challenging. But this moment demands something different. Submission to process, not surrender of identity, but acceptance of rules. And that's the part no one talks about. Public sympathy for Harry has grown. Many saw that courtroom moment, hands covering his face, and recognized genuine pain. But sympathy is not leverage. Empathy does not override structure. Time, meanwhile, is no longer neutral. Each week without resolution strengthens institutional footing and weakens alternative narratives. Because absence, once recorded in official frameworks, becomes history. There is something haunting about the inevitability of it all. When private pain becomes public currency, eventually the ledger balances. When identity is built in opposition to an institution, eventually that institution stops engaging. The monarchy is doing what it has always done. Surviving. Whether Harry returns to Britain as a private citizen, remains in California as a public figure detached from formal status, or attempts some fragile middle path, one reality remains unchanged. The crown does not bend around uncertainty. It restructures until uncertainty disappears. And that may be the final lesson of this entire saga. Crowns don't shatter dramatically. They don't collapse in spectacle. They endure by adjusting the framework beneath them, quietly, patiently, permanently. That morning in courtroom 3 at 10:14 a.m., a single sentence cracked something deeply personal. But outside that courtroom, something far larger was happening. An institution was recalibrating, not loudly, not emotionally, but decisively. And in the end, history may not remember the sound of a prince breaking. It will remember the silence that followed, and what that silence built.